Welcome back to Hardball. The not guilty verdict today for Casey Anthony was a surprise around the country, but a stunner to many who have closely followed the case down in Florida. Let's go now to Orlando and to criminal defense attorney Meg Strickler. Ms. Strickler, thank you for joining us. You've been following this case. Your own reaction as a professional defense attorney when you saw that jury verdict, what was it?
Okay, we got it.
You know what? I was surprised. I was expecting them to split the difference between death penalty to not guilty on all counts, and I'm surprised they did not guilty on all the major counts. What a shocker. And I really can't wait to hear from some of these jurors as to what they were thinking. But I'll be honest with you, legally, they definitely did not have a death penalty case here. They overcharged the case, and they did that as a prosecutorial ploy to get a death qualified jury. And that's what actually I think hurt them, because by going for such a strong charge, the jury went the total other direction and acquitted her on everything. She's probably going to get out on Thursday.
Well, with the benefit of hindsight, what was an appropriate charge, if there was one, to win a conviction, if there was one appropriate here?
Yeah, you know what? I was thinking second-degree murder or, voluntary manslaughter, something like that, because I do think she had something to do with it, but there's just not enough dots to connect with direct evidence that she's the one who sat down, premeditated this, even for 2 seconds, 2 months, 2 days, whatever. She didn't do that here. There's no way this was first-degree murder. I don't have a problem with the prosecution going for first-degree murder. I have a problem with them going with death penalty. And they did that to get a pro-prosecution jury, in my opinion, which is a death-qualified jury. People that are okay with giving the death penalty. When you have people who are okay with giving the death penalty, they're more prosecutorial-oriented. That's real obvious.
Well, let me play your job. Let me play defense attorney without a license. It seems to me they never were able to connect the attitude of that young woman. She certainly seems very angry, and maybe the kind of person who would get angry. Who knows? And the actual commission of the murder. They also never connected through habit or through apparent pattern abuse. They never showed her spanking the kid, never showed her yelling at her in public. No evidence that she didn't like the kid. And that the jury's supposed to say, slam, bang, execute this woman, put her away forever, either one, because we think, given all the evidence around it, that she must have done it. Is that it?
That's exactly right. And that's exactly right, because normally there's a thing called similar transactions, prior bad conduct. Those are different legal terms. There was not a single witness that got up there and said, I've seen her give that kid Benadryl because she's too loud. I've seen that give that kid to, chloroform or, Xanax or any of the different theories that were floated out there. Nothing. So why would you all of a sudden chloroform somebody? That doesn't make any sense. None of this did.
Last question. I was going to say Congresswoman. I'm used to Congress people on the show. Do you think the judge will give her more service, more time in prison, or give her what she's already gotten?
She'll get time served. I'm pretty confident on that. She was only convicted of the 4 misdemeanor charges. Technically, they could be consecutive sentences, which means one after the other. But generally, those kind of sentences are concurrent. She's already served close to 3 years. These are misdemeanor charges. I think she's going to be free on Thursday. That's my opinion.
Well, don't most defendants who are actually guilty, if not provably guilty, don't they all make up stories? I never knew that was a crime. If you make up a defense in a narrative in your own defense, is that criminal?
Absolutely not. I understand the burden of proof is on the prosecutor. And let me tell you something. I'm a criminal defense lawyer. It's all I do. We always are hearing different versions of things. We all hear different versions. We all perceive different versions. That does not make you a criminal, not even remotely. So I think the jury did well. They listened to the evidence. They listened to the lack of evidence.
Meg Strickler, defense attorney down in Florida, thank you so much for joining us on Hardball tonight in this stunning verdict. Up next, we're going to get back to politics and what happened when